Good morning. Welcome to the live stream of the interview conducted for our quarterly newsletter, the Billabong Bulletin. It is a privilege to have gotten the valuable opportunity of interviewing senior advocate Siddharth Luthra, one of India's prominent lawyers. In July 2012, Siddharth Luthra was appointed as the Additional Solicitor General of India. He was the special public prosecutor in the Nirbhaya case. He specializes in criminal law, white collar crimes, and cyber fraud. He has done an MPhil in, an MPhil in criminology from the University of Cambridge. He was conferred an honorary doctorate of law by Amity University, Noida. This brief hardly begins to cover Sir's list of accomplishments, but in the interview today, his wisdom and experience will surely be highlighted. Before we begin, I would like to make some more introductions and give a brief about the session today. In our newsletter's interview section, named Interlocution, we get an opportunity to interact with distinct personalities belonging to diverse cultures and professions. This not only helps us learn about various subjects, but also provides intellectual stimulation and builds confidence in our students. For today's interview, we have with us the alumni of the school who have a passion and deep rooted inclination towards law. With their help, we hope to ask relevant questions pertaining to the legal fraternity and talk about crucial issues and get exposed to how the minds of high profile advocates work. Today we have with us Ahana Rajan, who graduated from BHIS in the year 2018 and is currently in her third year at Nalsar University, and Vibhuti Rao, who graduated this year and is currently in her first year at law school at Symbiosis Law School, Noida. Another alumni, Ravati Singh, has framed the questions that I will be taking up. My name is Hia Sadho, and I am the editor-in-chief, and we have with us our literary coordinator, Ms. Noor Qureshi, and other members of the editorial board, Raina Saxena, Kashfi Mehta, and Paloma Jain. Without further ado, with the permission of our honorable guest, Senior Advocate Siddharth Luthra, we will now begin with the interview.
Great. Let's go for it.
Good morning, sir.
Good morning.
It is an absolute honor to be able to talk to you today. Welcome. So this is the first question of the day. From what I understand, the most basic objective of the law is to ensure justice for its people. However, the idea of justice could be quite different for different people as it's abstract. No two cases can be the absolute same. Hence, I wish to ask you that what according to you is justice, and how do we know that it's actually served in the truest sense?
We must understand that what we believe is justice very often is moral justice. And what the law requires is legal justice. Our societies, being a republic, being a democracy, we live or seek to live by the rule of law. We have the advantage of a written constitution. And the written constitution and its underlying principles has certain tenets. For example, for an accused, the presumption of innocence, your fundamental rights, the right against self-incrimination, the right to liberty, the right to free speech, the right to work as you wish, the right to move about freely. These are all the norms, the basic norms that define our society, which is a society governed by the rule of law. Now, when you will see this contrasted in the case, for example, if you remember about a year and a half ago, there was an encounter killing where some people accused of rape were shot dead by the police. At that stage, there were two sets of public opinion. One set of public opinion was, and it was actually a minuscule public opinion, that the police officers have used excessive force and they should be prosecuted, which is what the law says, which is what the rule of law is. But at the same time, you had the vast majority of public opinion saying that justice had been done. So we must understand that we as lawyers, and when I mean lawyers, it means lawyers, law students, judges, all of us, law teachers, all of us believe in legal justice. The difficulty with legal justice is that legal justice has three sets of norms. And I'm talking about norms generally. I'm not going to trouble you with the technicalities of the laws. There is the substantive law, that is to say, when the law declares something to be an offense which it believes is abhorrent. So, to give you an example, the law declares dowry to be an offense. It is a practice still prevalent. It's not that it stopped, but the social action of the law is that you declare this to be unlawful because a large section of population believes it's a bad thing. It's not a good thing for our society. This is not how rights are to be done. But yet it is a practice which is followed. And that's where the difference between public understanding of what is correct and the rule of law varies. On the other hand, you and I would agree that if A murders B, that should be an offense because taking of a life is criminal, isn't it? Now, there are, of course, what has happened in the last 5 or 6 decades, especially more so since independence, we have begun to increase the ambit of the law, the criminal law. As a result of which, we have new areas of life which are governed by the criminal law. For example, before the Harshad Mehta scam in the 90s, insider trading on the stock exchange was par for the course. So if I was a director in the company and I was playing around with my shares, nobody really bothered about it. It was considered an acceptable business practice. When we had the stock market scam and there was a crash, we suddenly got the SEBI Act, we regulated, we brought in norms. And today, there are lots of norms which prohibit certain actions which otherwise would not have been prohibited. That is the concept of rule of law, and that is the concept of justice which we impart. So when you go to a court, you go to the court, you have lady justice with the scales, and the lady is blindfolded. I've, Obviously, ladies are supposed to be traditionally more fairer than men. That's one thing which is very clear. And I'm also surrounded by a group of interviewers who are all women. Now, the point is, you have this lady justice with the blindfold and the scales of justice, and the idea is to deliver a result which is not influenced by either party. The idea is to deliver a fair result. And that is what I would call legal morality, the ability to work within our set of rules and deliver as much as possible, the best possible result. The best possible result will always not be satisfactory to all concerned. A victim may feel, well, this is a case which deserves the death penalty. Why is it life? The, the accused may feel that he or she have been harshly punished. But because we're a society functioning by the rule of law, we work in the domain of legal justice, and that is the concept of justice. We understand justice as per prevailing laws. Results as per prevailing laws is equal to legal justice.
Thank you, sir, for that enlightening response about how we strive to create a balance, imposing legal justice, and how differently the people might understand it.
I will be taking up the next question. In most law schools, the majority of students tend to go for corporate jobs. And even though they might have a passion for litigation, but like practical things like salary, job security, and stability lead them to choose the corporate life. Should this trend be countered?
I think you raised a very important existential question about the proliferation of law schools in India. And while my view used to be different, but I understand the practical implications much more now as I grow older. And I don't think wiser, but definitely older. The law schools, the 5-year program was created to provide this brand of ace litigators, this whole community of lawyers focused on litigation. What you really did was you selected good people, you gave them the best possible training, you honed them in a focused legal education with subjects which would help them enhance the experience of their legal education. As a result, when they came out of law school, they had the necessary wherewithal to do as well as anybody would in the Western world. This was accompanied at a time when litigation used to pay well. So I'll give you a small example. When I came back from Cambridge in 1991, that's a long time ago. A lot of you weren't even born then, I guess. Most of you weren't born then. I don't know if Miss Qureshi was also probably not
I
born.
was, I was.
You were? Okay, you don't look that old.
Sorry, I told my age right away.
You don't look that old at all. But what I was saying was, so when I came back, I was working at the princely salary of 1,250 rupees a month. My petrol bill used to be about 1,700. I used to go to trial court every day in a car, which is about 17 kilometers from my home. And that was the lay of the land. By the time I left the firm, they increased the salary to 1,500. At that time, the best of law firms used to pay 4,000 rupees a month. Now, you must also understand that litigation continued and continues to be at the trial court level very poorly paid. So, for a student who comes out of law school, especially somebody who's possibly had to take loans, whose family has supported them, and either by loans or by bank loans or personal loans, or have struggled, they really want a return on that education. At the same time that there was a proliferation of 5-year law schools, two things happened. Because I'll tell you, the proliferation of law schools happened it began in the late 80s, and it started in the late 80s, the 5-year law schools, and by the early 90s, they opened up, and then they went on an increase. Everybody started looking at 5-year law schools from Bangalore onwards. It was accompanied by a time when the economy in India opened up. So suddenly there were a lot more opportunities in the corporate sector, in the advisory sector. With the opening up of the economy in India, as India became more open to the rest of the world, a lot of people who wanted to look at India internationally started hiring young Indian lawyers. Most lawyers didn't want to necessarily go, but suddenly there was this generation of young Indian lawyers who were picked up by the best of law firms, because the foreign law firms had thought that they would get a toehold in India, a foothold, not just a toehold. And they began to enter the Indian market through proxies initially and through arrangements. And they also started taking a lot of these young lawyers to London, Singapore, New York. Now, you tell me, for a young lawyer who comes out of law school, a salary of, as I said, a few thousand rupees, 2,000 rupees is here, or $1,000, what would you prefer? And that became the commercial driving force. And I guess this answer is getting a little long, but there was a change. Today, of course, things have changed. Litigation is a lot better paying. And with COVID, litigation will get its due, because today we produce about 300 odd thousand lawyers every year, 300,000 plus lawyers every year. And there is an increased need for litigators, because as corporate transactions, as commercial transactions increase, there are going to be more lawyers needed. But the difficulty is that most of this work is high-end work by corporations and companies who can afford to pay good fees. So a lot of this increase of litigation is in the metros and the large cities, not in the districts necessarily, except in some of the states. For example, Madras, Tamil Nadu has a lot of good litigation, well-paying litigation. Tamil Nadu, Karnataka, Andhra Pradesh, Telangana, partly Kerala, Maharashtra, Gujarat, Haryana, Western UP. So there are pockets where there is a fair amount of litigation. Chhattisgarh has a lot. Odisha has a lot. So there's a complete imbalance. If you ever look at the map in terms of look at good litigation, and I'm looking at good litigation not from the client's point of view, but from the lawyer's point of view. Well-paying litigation, you'll find that wherever there is industrialization and commerce, you'll find it much better, or wherever there is government development activity. And these are the areas where you will see a lot of litigating lawyers. Otherwise, you'll find the litigator is basically surviving to make ends meet. And I can share with you, COVID has been a very difficult time. With the trial courts shut, there are young lawyers who have been in Delhi for a few months. They're even in the Supreme Court who are seriously thinking of going back to their hometowns because they cannot survive, they cannot pay their rents, they cannot pay their installments, they're under a lot of financial constraint. So the profession is going through a complete churning and recalibration. Clients are not willing to pay those kind of fees. So what's the next question? I hope I've answered that. And if I haven't, please ask me further.
No, of course, sir.
5 minutes here or there is not going to trouble me.
No, of course, sir. Your answer certainly puts a lot of more things in perspective and gives us a lot of things to think about. The next question will be taken up by Ahana Rajan.
This is a very precious time to spend time with young people. I always enjoy it. It makes me feel that I was young once. I hope that in your company, I'll feel younger again. So I enjoy learning a lot from you. Thank you. Go ahead with the next question.
Good morning, sir. It's an absolute honor to be able to speak to you here. So, my questions to you are regarding the challenges that the legal fraternity is facing right now. So, to be particular, if we look at the recent events, on one hand, we saw Supreme Court very swift action in Arnab Goswami's case. On the other, we've had numerous activists in prison for years and being denied something as basic as a straw. So, do you think the selective outrage towards civil liberties brings the very independence of judiciary into question?
Ouch, that's a tough one. I don't know if you've seen an article my wife Ketki and I wrote in the Hindustan Times. It was published last Saturday. It's on liberty and the Supreme Court. Have a look at it if it may interest you. Ketki was a full-time litigator, and I, of course, am. She's now doesn't litigate that much, but we write together often. The Supreme Court is comprised of 30 odd judges. Judges sit in benches of 2, sometimes 3. The individual philosophy of judges is now becoming the philosophy of the Supreme Court, and therefore it is often believed that we do not have one Supreme Court, but we have 15 Supreme Courts or 14 Supreme Courts. That's a concern because you need a consistent philosophy. In the United States and in the UK, the House of Lords used to sit as one court. So all 5, 7, 11 judges, as that case may be at the relevant time, 11, would sit together and they would determine an issue. And they would determine an issue which would settle the law for all over India. In India, what happens is, because judges sit in benches of 2, 3, 4, so there can be on the same day a divergent view between different sets of judges, especially on the issue of liberty. It's a philosophical approach. In India, our period of the 80s, when you had judges like Krishna Iyer, that was the high point of liberty when we were really focused on liberty. And there was a great sensitivity in the late 70s, post-emergency, and the 80s to liberty. Now, in the 90s, things changed with a lot of economic activity. There was a focus on economic crime. And that changed the way judges would look at liberty, because there was a balance between interest of the state, commercial interests of the state, of the revenue, and liberty. We have now reached a point where there is a variation. Very frankly, Arnab Goswami's case is a very good case in point, where the High Court declined to give interim bail. Now, frankly, did the High Court have power to give interim bail in a case where a person is arrested in a writ? Yes, legally the High Court did. It could have been done. But the High Court chose not to. That is also valid. Why did the High Court choose not to? Because the practice has become, and that's a prevalent established jurisprudential practice, legal practice, that wherever there are remedies under specific laws available, in this case, the remedy of bail, the right to go to a trial court and get bail, or the High Court and get bail. There are specific provisions for that in the Criminal Procedure Code. There is no occasion to get the same relief in a writ petition. And that has been settled by the Supreme Court in 2014 in a case that I had argued in 2017 again. So that is the settled legal position. Having said that, what we need to understand also is that the Supreme Court in Arnav Goswami's case takes the matter during Diwali vacation. No judges are sitting. The matter comes up. It is by the registry, fast tracks it. It is listed. It's a matter of liberty. It should have come up. It should be taken up on priority. I don't dispute that. But it happened to Arnav. The point is, justice is, if it is individual based, then we have a problem in our system. That's a problem which we need to address. In 1989, there is a lovely judgment called Ilyas Ayub. And the Supreme Court at that time, in the context of liberty, had cited Lord Denning, speaking, I think, in 1947 or 49 in the Hamlin Law Lectures, where he said that the practice in English courts was that if any lawyer interrupts the proceedings and says, "My lord, this is a matter of liberty," it is the duty of judges to stop all other work and take up the matter of liberty first. That is the principle which we must, that is the sensitivity which we as a society must attach to liberty. It's very important, because if it is taken by law, fine, but if it is not taken, if it's contrary to the law, or if it is a malified arrest or a malified detention, then we must show that sensitivity to human life and liberty, not just pay lip service. I think Arnav's case is a defining moment. It is important for the court now to see that you have acted in Arnav's case. Is it not possible for you to ensure that the principle of Arnav's case, to act with speed and expedition in the matters of liberty, apply to every ordinary litigant, whether he is Arnav or whether it is A or B or C, to the man in the street? Why should we treat people differently? I must tell you on an interesting note, the consequence of Arnav's case and a lot of plodding is that 3,000 odd matters which were lingering in the Supreme Court have been directed to be listed. And from January onwards, the court is going to be full of matters which were not being listed for one reason or the other. In this, I must add one thing. The president of the Supreme Court Bar Association had in fact written a letter that Arnav's case should not be taken up during the vacation, and why is it being fast-tracked? My view is different. My view is, treat it as a principle which you will apply, and not only the Supreme Court, every court in the country must show the same sensitivity to liberty. We're dealing with human rights in a society which is a democracy, in a society which is functioning and ought to function by rule of law. There is no greater right than liberty. And it's not a right you gave us. The state did not give us that right. It is inherent in every individual. So you can't take away my liberty unless you can show good reason. And that's the principle.
Thank you, sir. That puts a lot of things into perspective for me, and I'm sure for all of us. Sir, my second question to you is pertaining the contempt of court law. It's going to be a two-part question, a bit long, I'm sorry. So we know that contempt of court as a law was set up to maintain the authority of court and to prevent any impediment to justice. But in light of recent events, do you think that the judiciary should be placed at that sacrosanct position where it is beyond any sort of dissent or constructive criticism?
I'll answer it, if I may, a little diplomatically.
Absolutely.
I'll tell you why. I'm a micus in a matter where contempt is on. The matter is actually listed on Monday again for a set of lawyers from Bombay who have been abusive of judges, calling them criminals. They also started, once I started preparing against them, they started personally attacking me as well. They filed criminal complaints against judges and all kinds of nefarious activities, unfortunate activities. I really forget the word nefarious, use the word unfortunate, I would say. I believe that the power of contempt is essential. Its application is another issue, but it's very essential because We must remember, if you look at the American state papers, Mills states in the Federalist that the judiciary is the weakest of all body arms of government. It doesn't have the power of parliament to legislate. It does not have the power of the executive to enforce its decisions. It is dependent upon parliament to listen to its voice of conscience. It is dependent upon the agencies of the state to ensure compliance of its verdict. So, for example, if the Supreme Court or any court says that a person must be released from custody or writing must be stopped by the executive, till the police act or till the jail authorities release that person, the Supreme Court's order will be, or the court's order will be only on paper. So how does the court ensure the maintenance of the moral authority or the authority that the court has? How does the court ensure that nobody breaches its orders or its directions with impunity? That the only power available is of contempt. Remember, a strong, a vibrant judiciary is essential for this country because our nation is a nation of checks and balances. A strong, a stable judiciary is the only body that can keep legislatures in check by striking down laws which are unconstitutional and unconscionable. Laws that offend the basic structure, laws that distinguish between man and citizen, and creed and community. That's why we need the judiciary. Laws that are an incursion into our fundamental rights. For that, we need a strong judiciary. But their orders can't be paper orders alone. So while there may be a legitimate debate about the nature and extent of application of the contempt laws, the requirement of existence of the contempt laws is essential to the rule of law. And let me also assure you, the power of contempt is not a statutory power alone. It is not a power given by law. It is only because Parliament, of course, has enacted a law, the 1971 Contempt of Courts Act. But at the same time, the higher courts in India, the high courts and the Supreme Court, are courts of record, courts where records are maintained of their proceedings for time immemorial. And these are, in the English system which we have adopted, every court of record has the inherent power. It is part of its existence, the power to punish for contempt of itself. Just as the right to liberty is inherent in me, the right to punish for contempt is inherent in courts to ensure that their orders are not flouted with impunity. Right?
Thank you so much, sir. So the second question, which is somewhat related, being now that the application of laws like contempt and sedition is getting stricter, how do you think we protect the voices of dissent that seem to get trampled on?
Sorry, come again.
So now that the application of these laws like contempt and sedition is getting stricter, how do we protect the voices of dissent from being trampled on?
I think you're mixing two things. You're mixing apples and pears. Contempt is a law to enforce and ensure the majesty of the courts. Sedition is another element alone. You all study in Bhopal, right? Though you may not be there, but you do study in Bhopal. Bhopal had the Nawab families, the princely families. Is that right? Sedition is traditionally an offense against a sovereign. Now, I want to ask you a question. In a fundamental democratic republic, who is the sovereign?
The
Anybody
government,
wants- All right, Ms. Rajan. Anybody else here? Do you want to give an answer? Ms. Qureshi wants to say something. Here, who's the sovereign?
I would like to second Ahana's opinion. I might go with the government.
All right, here, what about you, beta?
I mean, with the very basic knowledge of law I have, it is the government who wields sovereignty.
All right, Vibhuti.
Sir, government backed by public opinion.
Okay. Arena, Paloma, Kashvi, we've run out. I'll tell you who the sovereign is. Open the preamble of the Constitution. What does it say?
we the
We the
We the people.
So how can you have a sedition offense against the sovereign when I am the people? I am sovereign. We all combined are the sovereign, this people. What is the logic of the offense of sedition in a country like India? We are not a princely state. We are not ruled. We are not like England. There are no kings, there are no emperors. We rule ourselves. And that is the reason sedition needs to go. While it exists as a lawyer, as a prosecutor, I must tell you, I will apply it. While it exists as a defense lawyer, I will work within the confines of that provision to help my clients. But is it not an element of a past which we left in 1947 and finally in 1950 when we gave ourselves this constitution? You know, sedition, how it got legitimized is a very interesting thing. Actually, sedition would not have come in, but in 1951, an amendment was made. I have written an article on sedition with a colleague of ours, Nitin Saluja. If Ms. Qureshi or students are interested, it's recently got published in Journal in the Northeast. There is a NGO run by a former colleague of ours. I will send you that article if you send me your email address. I think I have the email address from Sikandar's email address. So I'll send it to you on Sikandar's email address. You can share it amongst your students. It may be of interest to them. It's not that technical. It's not that technical. It's hopefully simple reading. And if you have any doubts, you're welcome to get back to me.
That's very kind of you, sir. I'm sure all of them would absolutely, including me, would want to have a read at it for sure.
So every one of you must first go and revisit the preamble today. We forget. Government is not sovereign. Government behaves as if they're sovereign. If we don't act for our rights, they will not let you have your rights. Any government, and it's irrespective. It's not a question of politics. Look, we have empowered them to ensure that our rights are protected. If those rights get infringed, then you have two methods. Challenge them within the framework of the Constitution. A. B. Use the courts. C. Every 5 years you get a chance to challenge them. Do you even go to vote? Some of you are not of that age, but do most people even go to vote? Or do they think it's a day for a holiday to spend time with the family or whoever? We have to feel committed to our democracy, and we have to feel that we have to participate in the democracy. Otherwise, we are failing ourselves and our rights. Okay. Now we are running a little tight on time, so you have to tell me how long.
Absolutely, sir. I was just coming to that. It's 9:42 by my clock. I'm not really sure how well you're placed. I'm sure the girls have a few more questions, but it will absolutely go by what
just give me a minute. I will just
you're
tell my
comfortable with.
next class
Absolutely.
that I'm running a little late. Just give me a minute, huh?
Maybe the girls can have the last question going in case sir is slightly tightly scheduled today.
one more last question, please.
Absolutely. I would request Vibhuti to do the grand honors for the last question for today. While I'm sure the children have a lot to discuss, and coming from you, all of us feel equally enlightened. But since you're pressed on time, I would ask Vibhuti to quickly wind up this session.
I'll tell you what, I'll give you a proposal. We can do this 2 ways. You do this last question. If you ever want to do another session any other time, maybe next week, I'm happy to do it. And we can do it for an hour, not a problem. I'll also take out more time, little lapse on my part. And secondly, if there are any questions which are unanswered, please email them to me and I'll respond. Whatever.
Absolutely.
I'm happy to do another section. I love spending time with young people.
Do you also have the option of availing both the options, like emailing you the questions and then having a session?
Sure, you have the option. You have both options, not a problem. I'm sure I've been rambling also a little today.
Thank you so much. Thanks. Over to you, Vibhuti.
Ma'am. So I'll just keep the last one short, sir. India has a high rate of crime and thus generates a voluminous amount of criminals. Thus, I felt compelled to think about what happens with them. So could you please discuss if whether the criminal justice system should be more punitive or rehabilitative? And are we putting them back into the society with some valuable skills to ensure livelihood and sustainable relationships? And I'd request you to end with a note for the youth as a word of advice. That's all, sir.
You asked me 5 questions in one. I'm going to ask them quickly.
Yes, sir.
Thank you. We sadly in India, first of all, I don't agree we have a high rate of crime. That's a perception issue and the media plays it up. So get that out of your mind.
Okay.
On a percentage population, we do not have a high rate of criminality, much higher than any other country. The tragedy is whether it's the National Crimes Record Bureau or otherwise, they have such incomplete data. You'll be shocked to know that when the Supreme Court started releasing people in 2020, because of COVID, they took out the suo motu petition and started releasing people. You would be shocked to know that the statistics available with them of people in custody were of 2018. Those are the numbers they used as a broad analysis, number one. Number two, the second problem that we have is that our criminal justice philosophy is not defined. Now, it can be 4 kinds. It can be rehabilitative, retributive, deterrent. Rehabilitative, reformative is similar. Retributive, deterrent, or punitive. The fundamental problem which we suffer in India is that there is no coherence as to our criminal justice philosophy, and there is no analysis of our criminal laws. Right now, for the first time, there is a complete analysis which is going on to all our criminal laws, and I happen to be part of that process, where we are trying to say that have a coherent philosophy or have a combination of 2 philosophies. There is the variation in sentencing is so great that people suffer. So for the same offense, people will be punished differently. Now, there are going to be different. So a man stealing a loaf of bread and a man stealing crores of rupees has to be differently punished. But 2 people, 2 men or women stealing 2 loaves of bread because of hunger ought not to be disparately punished. There may be a minor variation, but we have a problem on liberty because discretion rests with the judges, and it is again a matter of perception. So each person's individual life experience defines how that discretion is exercised, whether in sentencing, whether in bail or liberty, and therefore there is a level of arbitrariness which is abhorrent to the rule of law and the right to equality. So that's one fundamental principle you must understand. Secondly, when we did the matters on the increase of juvenile age, 16 to 18 in the Supreme Court, we found that the statistics did not bear out that crime is high or even juvenile crime is high, hard crime. Thirdly, are we treating prisoners? Are we sending them back rehabilitated from jail? No, we are not being able to do that. We have some experiments on open prisons. We have some experiments on rehabilitation, but there is a great degree of ad hocism in these measures. So you have a good DG prisons, they will bring reform and others will just be passing time in the jail. Now, this is the prisons needs a systemic re-evaluation, and we need to shift. There has been some shift from the colonial system of prison administration to a more modern system, but the vestiges of the colonial system still pervade a lot of our prison culture, and that needs to change. Madhya Pradesh, where you are, created about 20 years ago, 25 years ago, loads and loads of prisons. They thought they had a lot of criminals. They finally found those buildings had to remain empty. They've converted them to schools and hospitals and government buildings. Check it out. Last message for your students. I really mean this. You're the future. You're actually the future. What kind of future do you want to be? A future that spends their time on social media, a future that spends their time. You are also in the midst of an information age where there is an information assault on your senses. You're getting information from every place. The accuracy is not always sure, whether it's Facebook, whether it's Twitter, whether it's Snapchat, whether it's Instagram. You're being bombarded by information. And then your teachers come along and Ms. Qureshi says, there is one crazy chap who's going to give you a lecture in the morning and you get stuck with this as well. What a terrible situation for you. First lesson, start being discerning about the sources of information and start giving yourself adequate time every day to hear or read, be informed, contemplate and analyze. We don't have time to contemplate and analyze. Everybody's running. Nobody's got time. Our generation didn't know how good we had the fact that we had time on our hands. We never understood the value of it. Now one does. And initially when the knowledge age came, and this is the knowledge age, we just felt, we missed out and we came in too late when the internet with this proliferation. So it's so easy to Google something. So you get an answer, but do you get the deeper meaning behind that answer? What you're really getting all the time is views, not news, not information, but opinions. You must now hone yourself to divide in your mind the distinction between, to have a clarity between opinions and facts. Once you are able to do that, you will have far better tools, mental tools, to succeed and to change and improve this nation and to improve society. And that's what idealism is about. That's what your teachers have taught you, and that's what I expect from you. All the best.
Thank you, sir, for answering all the 5 questions so patiently. We're honored and we're so happy to have you here. That's all.
My pleasure entirely. Thank you.
Thank you so much, sir, for spending some time with our children and myself. I've never been so honored to be a silent spectator the way I've been today, listening from the other side, the questions and the enlightening answers as well. Before we wrap up this session, I would quickly request all the members to look into the screen so that we can try and freeze this moment. And of course, you can smile. Thank you. Thank you so much. Thanks.
You. And I look forward to hearing from you. Whenever, let me know, just get in touch with me again or tell Raspreet and we'll fix up another occasion. I'd love to chat with your students. It's a pleasure.
Absolutely, sir.
I really enjoyed myself. Thank you so much for this.
We enjoyed equally, sir. Thank you so much. Thank you. Have a great day ahead. And thanks to all the viewers who are watching us live. Thanks for sparing out time on a Saturday morning. Thanks.